Hi there, I'm Janan Jarrow.
And I'm Peter Poon.
And we are two of the lawyers here at eLaw Alliance. We've got another video for you. Today's video is going to cover the topic of bail. We're going to give you some answers to some general questions. We're not providing legal advice in this video. If you're looking for legal advice, call Peter or I directly. We'll be more than happy to answer your questions. So let's get to our questions. Peter, if I, let's say, have been arrested, what happens after I'm arrested?
Well, usually what happens, the police will take you into their cells. They will process you, fingerprint, identify you. They'll advise you of what the charges are. They'll read you your charter rights. And then they have the discretion to release you on two forms, either a what we call a PDA, a promise to appear, which will lay out your next court date and that you're promising them that you'll appear on that court date to deal with your charges, or an undertaking to a police officer with conditions. So what that means is it's a form where you are basically promising the police that you're going to follow certain conditions and appear on your next court date to deal with the matters. Now, if the police do not use that discretion and hold you for a bail hearing, then you'll be kept in their cells until your bail hearing starts.
Okay, what is a bail hearing?
Well, bail hearing under the criminal code, basically what it is for the court to decide whether you should be released or not after you've been charged and arrested to deal with your criminal matters. It is also called a judicial interim release hearing, JIR. This is where it's a first instance for the court to get involved. The Crown will present their case as to why you should or should not be released, and you'll get a chance to let the court know whether why you should be released.
Okay, and how long will they keep me in jail before I get a bail hearing?
Well, under the criminal code, the timeline is 24 hours. So the police will have 24 hours to bring you before a justice of the peace, which is representing the Provincial Court of Alberta, to have your bail hearing.
And is there any kind of consequence if I'm kept past 24 hours before I get a bail hearing?
Well, there are case laws that if you're being kept for an unreasonable long time, that the subsequent courts down the road can take that into consideration either for your sentencing or for your charges altogether. We've seen the Court of Appeal made it very clear that we need to adhere to the 24 hours. And the Crown's office is very well aware of this, and that they are speaking with the police forces all around Alberta to try and get everybody to a bail hearing before 24 hours.
Okay, and what are some of the considerations that are taken into consideration during a bail hearing?
So first and foremost really is the charge that you've been charged with, and then the next thing is your criminal record, whether there is one, and whether the criminal record is related to the charges that are before the courts now, and the circumstances of this new charge that you've been charged with. There's also the Crown is going to speak a lot about primary, secondary, and tertiary grounds. These are how they, under the criminal code, justified whether they should be keeping you in custody or not.
Okay. And can you give me a little bit more information? What is a consideration under the primary ground or the secondary ground or the tertiary ground?
Sure. I mean, primary ground is really the court and the Crown will look at whether there's a likelihood that you are going to come and deal with the matter, and whether that there needs to be some incentive for you to come to court. So these incentives could be cash incentive or could be sureties, just to kind of motivate you and also keep you incentivized to come to court to deal with these matters. Secondary grounds is the Crown and the court will look at whether there's a likelihood that you are going to commit further offenses or further related offenses, just like the one that you've been charged with. Tertiary ground, it's not very commonly used. Really, what tertiary ground is whether the consideration of public interest, whether there's a public interest to keep you in custody because of the circumstances that arise.
Okay, and who's normally present at a bail hearing? Who are the players?
So for the courts, we'll have someone for your first bail hearing is usually what we call a JP, a Justice of the Peace. They're essentially the judge for the Provincial Court of Alberta. They're the one that will make the decision. We also have the Crown Counsel, which will present evidence on behalf of the police. And there usually are duty counsel that are available. This is a free lawyer that's going to be available for you for just a bail hearing. And also you can contact your own legal counsel, and they can certainly contact the Crown regarding your file, and that they can speak to your bail hearing over the phone that way.
Okay. And I've heard that the prosecutors have the burden of proving you guilty beyond a reasonable doubt at a trial. Is this same burden present at a bail hearing?
So for the trial, that's correct. However, at a bail hearing, it's a balance of probability. Right? The expectation from the Supreme Court of Canada really is to release everyone so that they can then stand trial for their matters. Because the principle of presumption of innocence is an overriding principle for our justice system. Of course, there are other circumstances that's why the court needs to get involved to determine whether, because of your criminal history, your criminal record, and the circumstances, that they do need to keep you in custody, just to ensure that you will get to court to face these charges, and that they are keeping you away from the public in the meantime.
And I've heard during bail hearings that some people are released on cash bail, some people are released on no cash bail. What does that mean?
So the biggest difference is kind of in the wording. It's you're paying cash or money, or you're not paying money. We'll start with the no cash. This kind of goes to the primary grounds where what kind of incentive the court needs to place on you for you to come and deal with these charges. The no cash bail is that you're not paying anything to be released today. However, if you breach any of the conditions on your release, if you do not show up for court next time you're asked to do so, or you pick up new charges, then the Crown can and may come after you for the amount of no cash that they impose on your release. On a cash bail, it's basically, let's say your release is $100 cash. What that means is you will have to pay that $100 before you'll be released.
Okay. And I've heard the term sureties in the context of a bail hearing. What does that mean?
Sureties can come in different forms. It can be as a property or as a person. Normally as a property, you can put up certain properties as a surety, meaning if you, again, breach any conditions, don't show up for court, or you pick up new charges, then the Crown can and may come after you for that property that you put up as a surety. To just what you're basically telling the court is that you're ensuring that I will come to court. Here is my so to speak collateral to incentivize me to come to court. As a person surety, it could be your friend, your family, your parents, someone who's going to ensure that you will follow the conditions, someone that's outside of the justice system who in the community is going to ensure that you're going to come to court, follow conditions, and not pick up new charges. Now, being a surety, you have to get their consent. They have to understand what a surety is, and they have to be willing to come to court or go to the police office and report that you have breached your conditions should you do so. So there are certain criteria that a surety has to qualify for before they can be one, before the court can accept them as one.
Sort of like they're supervising you while you're on bail.
Exactly. They're basically, a normal term would be your jailer in the community, so to speak.
Okay. And what happens if bail, are there any circumstances where bail might be canceled or taken away from someone?
Yes, so we hear this a lot from Crown Counsel as well. Sometimes you already have release on other matters and now you picked up new charges. They're telling you, oh, we're going to give you a Section 524 notice. Basically what that means is they're giving you notice that they're going to revoke your previous bail. Meaning that if they are successful at the revocation of your bail, then it just means that you don't have bail for the previous charge anymore.
And then that person goes back to jail?
Yeah, usually if they're already out, It's very rare that the Crown will ask for that, but this is usually when Crown asks for this is that you had previous releases. Basically, the court has said that, okay, I'm going to trust that you're going to be in the community. However, you have shown that you're now back before the courts on a new charge, that you cannot be trusted, so to speak, and that they might revoke your previous bail, meaning that you don't have bail on that one anymore. So even if you have bail for the new matter, you're still going to be held in for your previous matter until you speak to bail on that.
And what are some examples of conditions put on someone's bail?
The standard conditions is to keep the peace and be of good behavior, basically meaning don't pick up new charges. Next one is to show up to court when asked to do so. It's very standard. You have to come to court when you have a court date. Some of the other conditions is we see a lot of domestic violence charges nowadays. A lot of it will have conditions such as no contact. So that would be no contact directly or indirectly with the complainant. So that means you can't have your friend or your family member contact that person on your behalf. That would be a breach of that condition. Or a no-go condition, meaning either an address or a radius of that address that you're not allowed to be in. So those are kind of the standard ones. The conditions really depend on your matter and the circumstances. It is not besides the standard ones that I said, the first two, all the other conditions are really kind of tailored to the circumstances, to the charge, both to protect the complainant and also tailored to you personally as well.
Okay. And so say I've been arrested, been charged, and I'm granted bail. What happens after I'm granted bail?
So at your bail hearing, if you're granted bail, then you'll be given a court date. That will be your first court date that you have to appear for your criminal charges. Right after you're granted bail, you'll be processed by the police. They'll give you a piece of paper that has the exact terms that the court has imposed for your release. Make sure you read those terms carefully and understand those terms before you sign it, because there are consequences if you breach any of those conditions.
So let's say I do breach my bail conditions. What are the consequences?
So it's another criminal code offense to breach any of those release conditions, and the police will arrest you for the breach and be brought before the court again for a bail hearing on that new breach.
Okay. And let's say my bail's denied after a bail hearing. What happens when it gets denied?
So if your bail is denied at the provincial court of Alberta level, your next option for bail or to get out in the community is a Court of Queen's Bench bail review. That review is not another shot for you to have bail. You really have to either show that there is an error made by the Justice of the Peace in provincial court level when they denied your bail, or you have new information for the Court of Queen's Bench to consider releasing you. And that process can take up to 4 to 6 weeks, depending on how soon you can get the transcript for the bail hearing, the initial bail hearing, so that you can make that application to Court of Queen's Bench. It may not happen all the time, but the other way that you could get released is in provincial court. Possibly the Crown is willing to reopen bail and look at it that way. But usually if you're denied bail at the provincial court level, that's very rare.
Okay, well that was a lot of information about bail. Thanks a lot, Peter. Stay tuned, we've got more videos and a lot more legal information coming your way.
Yes, and if you like the video, please click like and subscribe to our channel for more videos to come. Thank you.
See ya.